Hey, this is Kent Jones with Jones and Associates PC in Cleveland, Tennessee. We cover Bradley County, Hamilton County, McMinn County, Polk County, Marion County, and other areas on an as-needed basis. Today we're going into part 3 on divorce in Tennessee, and essentially this is getting into the category of divorces that come in as contested and are extremely contested. We've talked about what to do in the initial stages if there are problems, but what do you do once you get into the divorce process? Again, my answer is mediation. And do it one time or two times or three until it works. And then what happens in mediation is the mediator will produce a report, file it with the court. We'll get together, put together an order, file that with the court, and then put together the paperwork, which if you have children, is going to be an MDA on the property, and permanent parenting plan, child support worksheet, and then ultimately a final decree of divorce. On these cases, if there are going to be big issues on property or assets, it's important before you meet with your attorney to gather together all the information that you have. This is going to include, but not be limited to, individual bank information, joint bank information, 401ks, pensions, deeds to real property, emails, videos, text, and a number of other items. And that'll help us get started to kind of put together a picture regarding what's going on in that area. If there are significant issues with respect to the children after the initial stages are taken care of, and I'll refer back to orders of protection and things like that, then one of the tools at your disposal is to file with the court a motion to appoint a guardian ad litem, or the court may decide that they want to appoint a guardian ad litem without anybody filing a motion. And typically, a guardian ad litem is a neutral attorney, doesn't really know anything about the case at first. They're given powers by the court to investigate pretty much all matters, the circumstances in which the child or children will be living in each of the households, who all's living there, what type of household it is, the particular parent's ability to provide food, shelter, insurance, medical care for the children, and eventually at the end of the process, the guardian ad litem will put together a report and file it with the court, and that report, of course, can be used both in mediation and court proceedings to give everyone an idea of what somebody independently found out. The cost of the guardian ad litem are going to add to the cost of litigation, and those fees usually are split in half between the parties. That's really about all I have to say at this point in time about contested divorces. The next area I'm going to go into seems to be a really frequent question is what do I do if the other party, spouse, will not sign off on any of the paperwork? What do I do if they're out of town? We can't find them. What do I do if they're incarcerated? And it's amazing that, you know, in a lot of cases I've seen where people have been, you know, wrestling with that issue for years, not knowing, you know, what to do. And it's pretty much just, I guess, a lack of communication because you haven't talked to an attorney and found out. But you can put together your own case and bring it to court and put on your own proof and obtain a divorce if the other party is not going to be in a position or to work with you, or they won't, or they're not available, you can't find them, or anything like that. It's a little bit more difficult. You have to, you know, put on some more convincing proof, but that can be done. We'll get into that in part 4 later. So I hope everybody has a great weekend. I appreciate your time, and we'll talk to you later. Bye.